I'm Spencer Mazyck, and joining me now is Catherine Amirfar. She is a litigation partner at Debevoise Plimpton who has recently obtained a landmark victory on behalf of her client Edgar Morales in the first ever case of a gang member tried as a terrorist. This case will certainly shape the country's definition of terrorism. Welcome, Catherine. Thank you for joining us today.
Thank you very much.
So I want to begin by talking about the legislation that's at the heart of the case here. It's a New York State anti-terror law that was formed in the wake of September 11th. So essentially, what does the relevant part of the law state?
It was in the wake, and as you can imagine, all the emotion that went into the state lawmakers, particularly in New York. And what they basically came up with was the idea to have an analog to the federal terrorism law, which already existed. And the idea was to have almost a symbolic act, because most terrorism crimes would be federal jurisdiction. But to have a symbolic act to really show that New York was unifying against terrorism. So 7 days they enacted the terror law. And the relevant portion, the piece that was the case was all about, is this intention to intimidate or coerce a civilian population. And that was the key to the case.
Did they borrow heavily from federal statutes there for this particular law?
Absolutely. In fact, I think they themselves
it's almost
said,
identical. Yeah,
they themselves say they basically Xeroxed the federal.
Yeah.
And the idea really was to have a counterpart. And even the lawmakers, when they were interviewed after the first use of the statute, said they really thought it was of symbolic use only. So I think they were more surprised than anyone when the Bronx prosecutor came up with this novel idea of let's prosecute gang members as terrorists, because this is what the language is, and if it's just about intimidation and coercion, why can't a gang member be a terrorist? That was what was going through their heads.
So let's talk about the circumstances leading up to Mr. Morales getting charged under this terrorism statute.
So he was part of this group that that operated in the St. James Park area in the Bronx, and the whole animus, the purpose behind this group was to protect from rival gangs. So they weren't a heavy gang in the sense of gun runners, drug runners, etc., but really a protection against other rival gang members. And he became a very low-level member, part of the gang. He would basically go to parties with them, is how he got involved. And there was an incident in 2002 that was absolutely tragic at a christening party. And it really captured the attention of the entire community because it was so tragic. It resulted in the death of a 10-year-old girl and the paralysis of a teenage boy because it was a gang fight. And there were stray bullets, and it killed the little girl. So this was a very high-profile dispute, and that's when the Bronx prosecutor stepped in.
Morales was charged, I think, in 2004, actually, with manslaughter, attempted murder, weapon possession under the terrorism law, and there was also a charge of conspiracy here. But what was the theory that the district attorney used here to pursue him with these charges? And
it's a really good question. And as you point out, there was a 2-year lag. And what ended up happening is that the main gang members, the leaders of the gang, basically escaped New York. They escaped the jurisdiction. We think they're in Mexico somewhere.
They fled out of the country.
Exactly. Yeah. So the police investigation had focused on all of the leaders, the people that they thought actually perpetrated the crime. Lo and behold, years pass by, it's a high-profile case. They end up with Mr. Morales, who they'd picked up very early, who just charged them with, they charged him with trespass. They pick him up 2 years later, and now it's about terrorism. And there, the theory was that by being part of this organization called the St. James Boys, that even if it was about rival gang members, there was an intimidation and coercion of the civilian population. So you have to ask yourself, what's a civilian population? And guess what? The statute doesn't define it. And that's what the big fight was.
Were they saying it was the Mexican-American population here, though?
They were saying it was the Mexican-American population, but only within the confines of a park
Still limited.
In the Bronx. So it's, a 10-block radius around a park in the Bronx. Could that be a civilian population? And I think more troubling is the idea that if there's a violent act and it happens to have an impact of intimidation or coercion, that's terrorism. But you can imagine if you apply that standard or threshold, all kinds of conduct that we can never really imagine falling within the definition of terrorism as we commonly understand it would fall in it. And that includes, any altercation between gang members. It includes mob activity. Frankly, it would include...
Well, you can always say that as threatening some population or some subset of people.
Exactly, and it could be a bar fight. It could be Red Sox-Yankees fans, and suddenly, if there is a civilian population in that bar, you're suddenly calling it terrorism. So that was the real struggle with this case, is on their theory, any street violence could be considered terrorism, and that's why we challenged it.
Well, I will say that Morales was convicted on all counts, but can you tell us, how did the 3 crimes affect his sentencing, the 3 crimes that were considered to be terrorist acts?
What they did is basically they enhanced his sentence to life in prison. So the terrorism enhancement, or the terrorism law, was intended to apply to the worst atrocities that we as a society are grappling with. And so you can imagine that the sentences were the most extreme under New York law. So what it did is it effectively took what would have been, say, a manslaughter charge and took the sentence up to a life sentence in prison. So as a result of the convictions, he got 40 to life.
And when did you come to represent him? Was it on appeal?
It was on appeal. I got a call because his parents actually went into an organization called the Bronx Defenders, which does amazing work for that community on all sorts of issues, including criminal defense. And the executive director called me up because I'm on the board and said, would you take this case? We're very troubled by it. Look what's happening with the Bronx prosecutor's office. And I read about it. I looked at the evidence that was in the trial, and I frankly, I was outraged. And I said, sure, absolutely.
And you did it on a pro bono basis, that's correct?
That's right.
So I want to ask you, once the case reached the Court of Appeals, what were your arguments, which were obviously found persuasive by the court? I mean, they actually found it very persuasive.
They did. I mean, it's a remarkable thing to win on a criminal case in the highest court of New York.
Yeah.
So, well, we had won in the intermediate appellate court, but when we went up to the Court of Appeal, it was very kind of a simple common sense argument, because what the prosecutor was saying is, well, anything could be a civilian population. So what we focused on was, well, what are the implications of calling anything a civilian population? Could it possibly mean, as the prosecutor argued, that a civilian population could be as small as rival gang members? If that's the case, what's the implications? And you'll see in the Court of Appeal decision, they really came up on that theme and really adopted that theme as their own.
I did see that, yeah.
Yeah, and they talked about what happens if we take a terrorism, which has a unique definition in our society, to really address mass effect atrocities and apply it to commonplace street violence. And as they said, it diminishes the pursuit of terrorism to do that in the way that the Bronx prosecutor did.
Do you know how many times this New York statute has been applied, not contested in this application, but applied since it was enacted, and under what circumstances?
The Morales case was the first, and as far as we know, it's the first and only application to a gang member, not just in New York, but other states have similar statutes, so across the country. This was the first and only, as far as we know, and hopefully the last after the New York opinion.
The next question is, what do you think the significance of this decision is? I mean, I called it a landmark decision. Other folks have said the same thing. Why are people saying that?
Well, as you can imagine, New York is considered a leader in the field of terrorism law, and to have the top court in New York, come down and say, look, the terrorism is a unique definition, and we have to be responsible in our prosecution of terrorists about how we apply it. And they basically, cooler heads have prevailed. There is a sense that you have to cabin this to the truly unique circumstances that it was intended. And if you look at the legislative act itself, it says, as you can imagine, this is intended to go after terrorists, Al-Qaeda, the World Trade Center bombing, the embassy bombings, all the things, the Lockerbie flight bombing, all the things that we would normally consider terrorism. And so I think what this will do is it will make sure that terrorism prosecutions are principled. Because there's the additional wrinkle that we haven't talked about is, if you're tried as a terrorist, there's all sorts of evidence that comes in that normally wouldn't be in a criminal case. And that's a fundamental violation of a due process right to a fair trial.
And that's exactly what happened with Morales, correct?
Exactly. And all of this evidence that was completely unrelated to the 2002 incident was brought in under the rubric of, well, we have to prove terrorism. So things that Morales had absolutely no involvement in were put in front of a jury.
Things that the gang did that Morales may not have been a part of.
Exactly. And the Court of Appeal agreed with us. We had lost this issue in the intermediate appellate court, but the Court of Appeal agreed with us when we argued, how could this possibly be a fair trial if all of this evidence that was intended to prove terrorism, and you're now telling us that terrorism shouldn't have been charged in the first place, how could you let the conviction stand? And they agreed with us, and they gave us a new trial, which is a truly remarkable decision.
Will you continue representing Morales in the new trial?
Yes, we will continue representing him. We're back in the trial court, and right now we're actually, next week is the next status conference to figure out the trial date. What
will he consider a win or a victory in that trial?
I think vindication, nothing short of full vindication. And I mean it when I said that when I looked at the actual evidence that they had against Mr. Morales versus the conduct of the gang in general, it really violated the conscience. It was really, I think, a situation in which the terrorism law was used in order to allow all of this irrelevant evidence in. So if you actually look at what he was charged with and the evidence against him as a person, as an individual, it really doesn't pass muster in my mind.
Is he hoping for a lesser sentence?
As you can imagine, he's been in jail now for 8 years. So what he would like is to go home to his family.
Mm. Well, and so you mentioned that you also did this case on a pro bono basis. What percentage of your time do you dedicate to pro bono work?
It varies. I mean, I'm at a law firm, Debevoise Plimpton. It's a for-profit enterprise. It varies. We have a very strong commitment to pro bono, which is one of the big reasons that I joined the firm, that I continue there. And I think for my own practice, I just make sure it's balanced in my caseload. So sometimes it'll be 70% of my hours.
Yeah.
Other times it'll be 20%. But for my own kind of approach to my practice, it's such an integral part of being a lawyer that I think it's my responsibility.
And can you tell us about your your practice, really, what you're doing when you're not doing pro bono work?
Yes, what Debevoise pays me to do.
Exactly, exactly.
What I do is basically international litigation and arbitration, and it's a fascinating practice, which I very much enjoy because it allows me to bring in public policy into commercial transactions. So I'll be representing companies or individuals in arbitrations arising under treaties, in international tribunals like the International Court of Justice. So it's a very varied practice. And also if there's an international entity that finds itself in U.S. courts, we'll represent them. The United Nations is a client that we took a case into federal litigation for. So it's a very varied practice, but the locus of it is international litigation.
It sounds interesting to me, Catherine. Good luck with the new trial. I want to say thank you, though, for joining us today.
Thank you very much. My pleasure.
For more information on this or other topics, subscribe to BloombergLaw.com. You can follow us on Facebook and Twitter. Thank you for joining us. Bye, everybody.